Today is the 4th day of August 2025, approximately 2 months and 6 days to the court case of Nnamdi Kanu. And as you know, this man has been given judgment. He has been set free by many courts in Nigeria within this time of his trial, but somehow still finds himself in the dungeon where he is actually suffering as he is locked out of everything happening in this world. As you are aware, Nnamdi Kanu was abducted on June 2021, and on October 13th, 2022, he was discharged and acquitted by the second highest court in the land, which is the appeal court sitting in Abuja, where he was discharged of all charges. The court, having looked at the case, thought it wise to discharge the case at that moment in time. But of course, as you know, the federal government under Abubakar Malami, who was the Attorney General as at then, decided to still hold on to Nnamdi Kanu and refused to let him go. He refused to obey the judgment of the Court of Appeal, adding more fire to the lots of illegality that has been happening under his regime and under the government of Buhari, who you all know broke all relevant laws both locally and internationally to bring Nnamdi Kanu back to this country, an act which has been adjudged as an illegal rendition and a forbidden rendition that was done in Kenya and banned by United Nations. But many people do not know the details of that Court of Appeal judgment, and why is it that after that judgment, Nnamdi Kanu is still in the dungeon. For this video, I'll be breaking down the Court of Appeal judgment of 2022, October 13th, crossing all the T's and dotting all the I's, and checking if actually there was a loophole in the judgment or if it was just a normal witch hunt, which we are already used to by the Nigerian government to keep on frustrating Nnamdi Kanu. Because by right, that was the moment Nnamdi Kanu should have walked free. So whatever you're doing, I advise you to drop it and focus on this video, or finish it up, then come back to this video later, because you don't want to skip a bit. Kindly like, share, and subscribe to my channel. Please turn on notification and click on that bell and select all to get notified whenever we release a video. So join me as we dissect the October 13th, 2022 Court of Appeal judgment that granted Nnamdi Kanu his freedom, a freedom of course we all know he is still yet to enjoy. Let's go. The Court of Appeal in Abuja delivered a landmark ruling on October 13th, 2022 in Appeal Court Case File number CA/ABJ/CR/625/2022, which was filed by Nnamdi Kanu. The court's judgment was clear, firm, and historic, addressing both constitutional and international law violations. The Court of Appeal discharged Nnamdi Kanu of all remaining charges, effectively striking out the 7-count amended charge of terrorism and treasonable felony pending at the Federal High Court, Abuja, also declaring that he should never have been tried or arraigned in Nigeria in the first place due to the illegality of his extradition. The court also emphasized that the manner in which Nnamdi Kanu was brought back to Nigeria from Kenya violated international laws and rendered the trial illegal. He was abducted in Kenya by Nigerian security agents in 2021 of June. Also, there was no formal extradition process through Kenya or international courts. Also said that this act was declared a flagrant violation of international law and an affront to Nigerian constitutional order. The court noted that the federal government breached Kanu's rights to personal liberty fair hearing, and due process. They said that his forceful repatriation or rendition was a gross abuse of executive power and nullified any proceedings arising from it. The court invoked the doctrine called Clean Hands Doctrine. It said, a government that comes to court with unclean hands through illegality cannot benefit from the court's jurisdiction. Since the FG flouted both Nigerian and international law in bringing in Kanu back, they forfeited the legal right to prosecute him. Therefore, the Court of Appeal held that the Federal High Court had no jurisdiction to entertain Kanu's trial anymore. Also, that any trial that follows an illegal arrest is itself illegal and void. So this is the final verdict. The trial court is divested of jurisdiction to entertain the suit. The appeal court succeeds. Nnamdi Kanu is hereby discharged. That was the ruling of the appeal court on the 13th of October 2022. Putting this judgment side aside with the judgment of Kenya this year, 2025, you will also see lots of similarities in the way the judgment went. That means something struck out in the two courts. Something similar played out in the court. The Nigerian Appeal Court held that Nnamdi Kanu was illegally renditioned from Kenya, and illegality cannot breed legality. The Kenyan court on its own side also held that he was extraordinarily renditioned against his own right. He was tortured and he was housed in an unknown place, kept against his human rights, and a subsequent kidnap and abduction to Nigeria was illegal, null, and void. This second judgment from Kenya came about 3 years after the appeal court gave judgment to Nnamdi Kanu. So let us go back to the appeal court judgment. After October 13th, 2022, Abubakar Malami, who was the Attorney General under the last government, decided to hold on to Kanu tightly and rather throw him deep in the dungeon of the DSS rather than obeying the court. This shows the high level of impunity that exists in the country, Nigeria, and why the judiciary is not and no longer the hope of the common man. Instead, the judiciary looks like a weapon for the government itself. If not, tell me, what power does Malami have over the Nigerian court? How can a single man himself decide what judgment he should obey and what judgment he should not obey? That sets a wrong precedent and ultimately will lead to the collapse of Nigeria itself, according to Nnamdi Kanu, that has always said that one day the zoo will collapse. What Malami did was to lie and tell the world that the appeal court itself never acquitted Nnamdi Kanu, only discharged him. Please, ladies and gentlemen, what is the difference between discharge and acquittal? I will help you. When you say discharge, you mean this case, because of technical reasons, we can no longer continue with this case. It is a closed case because you abducted this man, and the law says that you cannot abduct a man and come to equity with unclean hands. Secondly, when you say acquittal, it means the case has undergone trial and the court has found that this young man is innocent of the charges against him. So the difference between the two, when the court says, I only discharge this case, the court is discharging the case based on technicalities. Whereas when the court says, I acquit this case, it means that I have tried this case and I have seen that the charges inside this case do not hold water, or there is no prima facie case. When you combine the both, you see discharge and acquittal. It means this case is discharged and this case is also acquitted. Now, Malami argued that the Court of Appeal did not actually acquit Nnamdi Kanu, only discharge him. But where you see he went wrong is that there is actually no difference between discharge and acquittal. These are just two languages that are oftenly and frequently used side by side, because the acquittal itself has a different language and is just a legal coinage, because when a case is discharged for technical reasons, the case is discharged for technical reasons, because courts have due process. And I'm telling you, there are ways of filing cases in court, and there are also procedures of pursuing a case in court. Even if you have a strong case, even if you have a good case favoring you, if you go against court rules, if you pursue illegality to pursue your case, the judge in his power can discharge that case. He may not use the word acquitting the person involved. He may use the word discharged. And I bet you, discharging means that case has been lost by you for technical reasons. It doesn't still mean that you cannot appeal the case, but you cannot hold on to the person citing because it wasn't acquitted. Therefore, you still have a right to hold upon the person itself. The appeal court is the second most powerful court in Nigeria, and I believe its judgment should be binding on every ramification. Going with the fact that up till the moment of the appeal court, the Nigerian government was yet to provide sufficient evidence to nail this man to the point he was at that time. So coming back to the Kenyan government, giving the same judgment telepathically that of appeal court, it goes a long way to show the judicial rot in the Nigerian system and why Nigeria is not going any better year to year. Sometimes I ask myself, what are Nigerian judges doing to save the judiciary from all this interference? The political interference is just too much. It is glaring. And when we have selective justice and tie people down based on their ethnicity, religion, and where they come from, you end up complicating legal jurisprudence in rigmaroling of the legal structure or upsetting the balance of justice. And once the justice system in a country fails, that country becomes a banana republic. Slow and steady, Nigeria is getting into that point of becoming a banana republic. Nnamdi Kanu has been set free by 6 courts already. Even before October 13th, 2022, he has been found innocent by 4 courts under 1 year between June 2021 and October 2022. But what did the federal government do? Each time Nnamdi Kanu gets judgment, they draw him back to the DSS dungeon and leave him there. That begs the question, is Nnamdi Kanu actually facing trial, or is Nnamdi Kanu facing persecution? October 10th is the day of Nnamdi Kanu's judgment, and I'm calling upon the relevant authorities right now to release this man, discharge and acquit him of all charges, release him unconditionally, and of course pay him compensations for this loss of time, frustration, and political judicial witch hunt, whichever or joint ever. But keeping him in the dungeon means that in Nigeria, power belongs to certain people and not the people that put them in power. And that is the reason why Ndi Igbo and of course Biafra want to go, because they cannot live in an unjust society, a society that victimizes people, a society that criminalizes excellence, a society that targets people based on their ethnicity, their religion, and their social status in life. In Nigeria today, only the rich have a hope of better incentives or better security. The poor have no place in the society. And of course, if you are from a certain tribe, just know that there is nothing for you in that contraption called Nigeria. The playground for the British. Spotters family worldwide, watching me from around the world, I appreciate all of you. We are a family of truth, a family of purpose, and a family of faith. And as you know, with faith, we can move all mountains, as nothing is impossible. Wherever you're watching me around the world, from Asia, America, Europe, Africa, Antarctica, and all the continents in this planet, God be with you. Remember to be good to your brother and treat that Igbo man around you as family. But as family, we mount for Nnamdi Kanu 247, waiting for the day he will walk out of that dungeon with his head up high. I have been your host, Chi Ne Du. Thank you for watching my video. So I see you next one. Peace.